Hello, we are members of the National ERA Publication Task Force and would like to present our position on why the ERA is presently ratified.
The Equal Rights Amendment became part of our Constitution on January 27, 2020, and it is required to be published as the 28th Amendment to our Constitution.
Over 200 constitutional scholars agree that the Equal Rights Amendment is presently ratified. The states of California, Minnesota, Michigan, Hawaii, and Illinois have all recently passed resolutions affirming the ERA is currently the 28th Amendment and calling on President Biden to publish the duly ratified ERA. On July 14th of this year, Representative Cori Bush introduced House Joint Resolution 82 into the House of Representatives.
Senator Kirsten Gillibrand of New York introduced companion resolution SJ Res 39 on July 27th, stating the ERA has been validly ratified, is enforceable, and the Archivist should certify and publish the ERA as the 28th Amendment without delay. SJ Res 39, now known as the ERA Now resolution, is a parallel congressional strategy and in no way conflicts with SJ Res 4, which had 51 senators vote yes on April 27, 2023. A congressional resolution is not necessary to effect publication.
In September of 2022, President Biden's lawyer, Sarah Harrington, stated, quote, "The Constitution does not contemplate any role for Congress at the back end. Congress proposes the amendment, it goes out into the world, and the states do what they're going to do."
However, the mere current existences of HJ Res 82 and SJ Res 39 are powerful messages to the Archivist and the overseeing executive, President Biden, to act now to certify and publish the ERA without delay.
The president has a constitutional duty to take care to enforce 1 U.S.C. 106B, which gives the Archivist clearance to publish an amendment once 3/4 of the states have ratified.
The 7-year deadline is not part of the Equal Rights Amendment. It was in the preamble and not voted on by the states. The founders were very clear that the balance between the federal government and the states must be equal in the amendatory process. By allowing the federal government to decide how long states have to ratify one amendment over another, this balance of power is clearly violated.
Those in power have no authority to deem the deadline valid. The constitutional law is clear. As per Article 5, upon ratification of 3/4 of the states, the amendment shall be adopted.
The ERA should be immediately published, and any legal issues would be decided by the courts, with the burden of proof shifting to those who are anti-equality.
For those who are frightened of this extremely conservative, textualist Supreme Court, fear not. By having had Senate hearings this year and House hearings the year before on the Equal Rights Amendment, our pro-ERA leaders have ensured that the matter is clearly classified as a political one. The Supreme Court is not allowed to weigh in on matters that are seen as political questions.
Secondly, this court has repeatedly asserted an originalist, textualist position on the Constitution. There is now text in the Constitution explicitly requiring equal treatment for all, regardless of sex.
As Vice President Harris is saying, quote, "Every woman should have the freedom to make decisions about her own body without interference from the government," unquote. If women cannot control their reproduction, they do not have equal rights. Roe cannot be codified without the Equal Rights Amendment in place.
The Dobbs decision effectively allows the court to have the freedom not to use the strict scrutiny standard of review. The ERA, however, provides the textual basis Supreme Court Justice Alito claimed was not present when they decided to overturn Roe v. Wade. With the ERA, Women's bodily autonomy would be a fundamental right under the rubric of equality as opposed to privacy.
The president has the opportunity to do the right thing right now.
Publishing the ERA will be President Biden's most historic act.
We urge everyone to stand up for our democracy so that 180 million of us can no longer be relegated to second-class status by our courts. President Biden will, with one phone call, ensure equal rights for us all.
Simply put, one cannot be pro-equality, pro-women's rights, pro-LGBTQIA rights, or pro-choice unless they are calling for the immediate and legitimate publication of the Equal Rights Amendment. Thank you.